If you think from the end backwards, it will often help you narrow down the issues that you need to raise during the witness presentations. And then, of course, your opening is where you get to present it all in the best possible light so that you make a really good impression at the outset. So let's segue into that briefly. Judges really appreciate a good off-note presentation. And off-note means that you've got students who have it memorized. But the key modifier here is a good one. It is really not fair to your students, and it's really not going to increase your score much if you insist on them memorizing and presenting and they can't do it well or comfortably. Again, this may be higher up in that hierarchy of point scoring, and I certainly would not start there, but it's something to think about. If you have students who have the time and the ability to present an opening statement without notes, maybe to walk around the courtroom to the extent that the judge is allowing them to do so, that will play really well, and it will get you good points. Now, the content matters a lot too, but if they can do it without notes, it's going to be better. But the downside risk is, like I just said, if they can't do it well and they forget, or if they have notes and they have to go back and start flipping through the pages, you've pretty much undone the good that you were trying to do. So again, it's something that you develop over time, but if you want to score the maximum amount of points, going off note is the best way to do it. Now, that would also be useful in a cross-examination of an adverse witness. And of course, all cross-examinations are adverse in mock trial. It's good to have a list of questions to make sure you don't forget something. Real lawyers do that all the time. But it's like the coaches were telling you in their presentation. Your attorneys have to be able to think on their feet and actually listen to the answers they're getting, because it might lead them down a path that hadn't been on their list of questions. And judges usually pick up on that. Judges will be able to tell when somebody is extemporizing in a good way. And if your students have the ability to do that, they're going to score a lot of points by showing that they can follow a thread that clearly wasn't expected by them out to its end and then tie it off neatly. Again, it doesn't occur often, but it's something that if you have the time and you have the students who are able to accomplish that, it's a good thing to do. And that goes right back to the beginning about getting them comfortable in a courtroom. The more comfortable they are, the more likely they're going to be able to do something like that. Now, backing down the pyramid a little bit, there is no substitute for having a good, solid direct and a good, solid cross-exam. I mean, you want to start with the basics. It's like you heard. You have to go through the materials with the students. They have to figure out what the points are and make sure that the points get made. But beyond that, there's got to be a little bit of room for the give and take. One more point about the lawyers, and then I'll move on to witnesses briefly. You heard some talk about the rules of evidence. A really good way to score points, both with presiding judges and with performance judges, is to know the rules of evidence and use them effectively. And I would suggest that you have 3x5 cards on your most salient issues, so that they're handy and so that your student has the rule number available to him or her. Some of the stuff like basic hearsay or relevance or so forth, they may not need to have written down. And really, you have to have some basic knowledge as a student lawyer of the way the rules work. You're just not going to make it during the competition. But hearsay is tough even for real lawyers, and it's tough for real judges. And let's circle back to the very first point I made. Some of the judges are going to get the rulings wrong because they're not comfortable or don't really understand the nuances of hearsay or some of the other rules that are available to your students to use. The best way to prevent an adverse ruling that you do not deserve is to be able to quote to the judge a rule number. And when I say you, that's your students. You're behind the bench just chewing on pencils, hoping they do the right thing. And the best way to ensure that they do the right thing is to make sure that they've got their notes handy and are perhaps comfortable talking to their teammates. Because remember, you're allowed to talk, and they should be comfortable talking to each other with the permission of the court. I'll give you one quick anecdote, and then I'll move on. In one of the cases a couple of years ago where I was a coach, there was a pretty subtle two-step evidentiary question. And it involved two different rules that intersected in an unclear way. But once you put it all together, and if you understood the rules of evidence, it became clear. Regrettably, the judge that we had, the presiding judge who had to make the ruling, was unfamiliar with the rules. Fortunately, the presenting attorney had them written down on a 3x5 card, was able to invoke the actual rule number, or the two numbers, and the judge actually took the time to find an evidence book and flip through it and find the rules and make the correct ruling as a result. Now, I don't think the score appreciably went up or down as a result of that. In fact, I think we lost that round ultimately. But the point is, you want to be prepared in case you run into a situation like that. And the cost is minimal. Once you've identified the issues, if you have them marked and you've got the rule numbers ready, then you can go forward pretty easily. With regard to witnesses, witnesses don't score as many points as lawyers, but they can win or lose a match for you. We were talking before, both of us, about how we really like seeing an entertaining witness testify. Judges love that stuff. You might think, oh, it's kind of cheesy, it's kind of melodramatic. I got to tell you, I've seen some witnesses testify at the state and the national level where I just thought they were way over the top. And the judges at the end went out of their way to compliment these witnesses on what a good job they did. So it's really hard for a witness to overdo the character. If you've got the nutty professor, if you've got the distraught widow, play it up. Find your actors in your school. Get the thespians involved. And you're really going to get that extra 1, 2, maybe 3 points. And like I said at the beginning, if you've got a split verdict and the difference is 1 or 2 points, which it often is, a good witness can win or lose the match for you. An example I've used before is they're the extra point kickers, the field goal kickers on the football team. Nobody wants to interview them after the game. They all want to go talk to the quarterback. But at the end of the season, when you add up the points scored, very quietly, they've made the difference in when the team won and lost. So having said that, the last point I'm going to make is the unfair extrapolation point. And apparently the rule's been corrected. I've been a big advocate of avoiding unfair extrapolation claims. I don't think they help. Judges really do not like them. It's clear that judges don't know what to do with them. Nobody wants to have to deal with it. It's like taking something messy and smelly and putting it on the table in front of the judge and saying, here, now you deal with it. And judges don't want to do that. So I think it's much better this year that you don't have to worry about point deductions for unfair extrapolations. Without having read the rule, and I confess I haven't had a chance to look at the materials yet this year, all I can say is that the best way to handle these situations before, and certainly the best way to handle it now, is to have your students ready to cross-examine the witness in an appropriate fashion to make sure that they can convince the judges that this was not part of the materials and the person was reaching beyond the materials in an unfair way. And the judges, at least the ones who have read the materials, will get it. And most of the judges have read it, and most of the judges do get the materials, but you've always got to prepare for the ones who may not have done all the work they need to do. I think that's all I want to say right now. I do have to leave a little bit early today. That wasn't my intent, but we're swearing in a new United States attorney today at the federal courthouse, and I have to be there at 3:30 with a robe on. So I'm going to stop talking now and turn it over to my esteemed colleague, and then I will be slipping off quietly stage right in just a moment.
Thank you. It won't be the first time someone walked out on me. So. Anyway, I want to, first of all, thank you for all taking part in this, and I really appreciate the time you put into it. And I really admire teachers, especially since one of my daughters recently graduated college and became one. So I appreciate you and understand what you're going through so much more. So thank you for that. Judge Crocker mentioned that different judges look for different things. That's very realistic. As attorneys, we have to deal with juries, and different juries look for different things, and we're never really sure what we're going to get. It's like Forrest Gump said, it's like a box of chocolates. You never know what you're going to get. But I think from my experience, the performance judges are there for two reasons. First of all, education. We want to see what it looks like from the other side of the bench. Most of us aren't judges in real life, and we're always presenting things to the judges, but it's neat to see the students, how they, what a good job they often do in presenting their case and how they build a theme and how the theme plays out when you're on the other side listening to it. If you can get the students to the point where they actually, and they probably will, teach the judges something about the case, because most of the judges don't read all the materials that much in depth, or if they do, they don't remember everything by the time they get into the courtroom. So they do have to educate the judges as to what the case is about, and you've heard a lot about the theme, and that's important in doing that. So you do have to work on that. The other reason that we're there is entertainment, frankly. These cases are entertaining. We enjoy seeing it, and especially the students who are playing the witnesses, how much they get into the role, and they do have to do that. Judge Crocker mentioned how important conduct and dress is, and the phrase I like to use or remind the students is that when they're an attorney, they are an officer of the court. So that's how they should act. The witnesses should act as in character for their witness, whoever that is. And the whole time, not just when they're on the stand, but the whole time in the courtroom. As far as preparing your student witnesses, what I think you should be doing is turning to your colleagues who work in your theater or drama departments, if you have them, or if there's some in your community, and maybe bring them into one of your sessions when you're preparing and have them give them some tips. I'm not the one to do that. I was never in theater or drama in school, although I had a daughter who was, and I tried to get her involved in her school's mock trial program, but she was too busy with the theater and drama. But if it doesn't conflict too much with your program and schedule, see if you can try to arrange a meeting with those people. The biggest thing I think they can lend is some degree of poise, how to act so that if something goes wrong during the trial or differently than they expect, what I like to say is don't let them see you sweat. Act like, okay, well, I tried it, didn't work, that's not the end of my case. So that goes a long way towards enhancing the entertainment value, I think, of your case, and therefore your score. Now, as far as the theme goes, how to build a theme, there's all kinds of ways. I did coach a team for a few years, and one of the things I like to do was, whether you have a whiteboard or just a blackboard or an easel with a flip chart, make a chart, and down the